And good afternoon, everyone. How's everyone doing today?
Yeah.
Praise God, right? For another day, another opportunity to breathe air and to live life and to make a difference in our lives and the lives of others.
Yes.
Thank you for having me. So I read an interesting report the other day, and it said that 40% of individuals 60 years or older will need nursing home care, level care at some point. 40% of individuals 60 years or older will need nursing home level care at some point. So the discussion that we're having here today is critically important to make sure that with proper planning, that if any of us should be in that 40%, we'll be okay. I'm Nego Pile. I'm an elder law attorney, and I help individuals plan to make sure that those uncertainties, and even the certainties that they face, that they are going to be okay. I have one of my employees, Zainab, here. She's going to be videotaping, and she's also going to be at the table handing out flyers. So I want to make sure that everyone got a flyer today. Did everyone get a flyer? If you didn't, just raise your hand and we'll make sure you get one. Because we'll talk a little bit about that flyer. All right, is it okay if I walk around, folks?
Yes.
All right. All right, so we're going to talk today a little bit about long-term care planning. What is long-term care planning? Right? Long-term care planning, or long-term care, is the level of care that any of us would need if our health declines and we can't do our daily activities. Eating, bathing, toileting, dressing, getting out of bed, those things, right? So if we ever need help with those things as we age, or even, a catastrophic injury, we're going to need help. Traditionally, what happens as we age, we start to decline in our health. That's why it's important that we take care of our health now. There are certain things that we can do. We can walk. Today is a beautiful day, right? You get up and you walk 30 minutes, right? I was joking around with one of our guests today. I said, I'm going to get my steps in today. I try to make sure I do that, right? So, but inevitably, life hits us with a decline in health. And if our health declines so drastically that we need help, the help of others, to help in those activities of daily living that I just mentioned. That's where a nursing home or caretakers come in. And so long-term care is dealing with that possibility, the possibility of a decline in our health and the need for caretakers to help us, assist us with the daily activities that we do. So part of my job is to make sure that we don't get hit with surprises, right? Because guess what? Long-term care comes with a cost. And so we have to be able to plan on how we're going to pay for long-term care. So that's what we're going to talk about today. So this is going to be interactive. There's going to be a period where we can ask questions, where I'll provide some answers. But that's the scope of the discussion today. So an integral part of long-term care planning, right, as I mentioned, is how do we pay for this? You can pay for it with long-term care insurance, right? So long-term care insurance is that insurance that you purchase to pay for those costs associated with someone helping us, whether it's a nursing home or caretakers coming into our home, right? But long-term care insurance is expensive. It's very expensive. So a number of people don't have long-term care insurance. By raise your hand, how many people in here have long-term care insurance? And that's a reality. So if we don't have long-term care insurance, how are we going to pay for long-term care costs? That means that we have to pay for it privately with our own money. The money that you've saved, the money that you may have in your retirement account, even the home that you own, right? But let's talk about how we protect those things, right? And if you need to pay privately and you run out of money, then who pays? That's where the government comes in, right? Medicaid. Medicaid for long-term care, right? So some of the things that, you know, a lot of folks aren't aware of is that you can plan to protect your assets, your property, the things that you purchase, the things that you work for all your life, and still qualify for Medicaid. Really, yeah. We're going to talk about it today. And so that's the planning that a lot of individuals in other communities do. And they plan. And they're able to protect their assets. So I'm going to show you and talk to you about how you can do that. Can I get an amen?
Amen.
So when we talk about Medicaid, there is a requirement, right? There is a requirement in order to qualify for Medicaid. Now, people may remember or know Medicaid as Medicaid for health insurance, but Medicaid covers more than health insurance, right? It covers long-term care costs. We're going to talk about the long-term care costs that Medicaid covers. So, in order to qualify for Medicaid, there's two ways that you can do this. There's the traditional planning, right? You come in, speak with me, or you speak with an elder law attorney, and you're able to plan ahead in life. And then on the other side is the crisis planning. Crisis planning is when you haven't planned ahead, but you need, or a loved one needs to go into the nursing home tomorrow, right? So we're going to talk about both. The traditional planning. How do we plan to protect our assets, right? So that if we should ever need long-term care, we don't have to spend down our assets, we don't have to spend or sell our house, right? We don't have to sell our car, all these things, right? So, the first thing that we'll do when you come in and you speak with me, right? I'm going to ask you some questions about you or your loved one that needs long-term care plan. Their health history. Health history is so important, right? Because it gives us an indication of what the possibilities are or what health issues you may face, right? And that's important. It tells us, if you have a history of family dementia that starts early, right? That starts in the 60s, and you're coming in and you're 55, we know we've got a plan for this, right? That's why family medical history is important. We're going to have those discussions. We're going to talk about those things. Next, we're going to talk about your current health. How are you doing? What issues you're facing, right? Then we're going to talk about your finances. We're going to talk about whether you own a home. Do you have retirement money? What is your income, right? We're going to sit down and we're going to talk about all these things because we need to be able to, I need to be able to understand how I'm going to be able to help you, right? So as you provide me with all of that information, I'm going to look at all of that. And then I'm going to talk strategy with you, right? So if you come in, you're 55, you're married, you have a family history of dementia that starts in the 60s, a parent has dementia, currently Karen is, in one of your siblings' home, the sibling is taking care of that parent because they can't help themselves. So what we're going to talk about the documents that we need to put into place for you, right? Right away, we know we got to talk about powers of attorney, right? Everybody knows what powers of attorney are?
Yes.
All right. Somebody give me an example of a power of attorney. Who wants to raise their hand and give me an example? All right, we got somebody over. Do we have a mic?
A medical power of attorney. A medical power of attorney is a person that can speak for that individual in case they cannot speak for themselves, for what they want their final wishes to be medically.
Amen. That's it. A medical power of attorney. And what she said is that medical power of attorney appoints an agent. The principal, the person who is drafting that power of attorney, appoints an agent to be able to speak for themselves, to speak for them, right? If they are unable to do so. So that principal, the person drafting, the person giving that power in that healthcare medical power of attorney is giving that power to someone else, an agent, to make medical and healthcare decisions for them. And also where that person can live, right? And what other kind of powers of attorney do we have?
Financial.
Financial? Come on, brother. Talk about it. What's the financial power of attorney?
They're able to make the financial decisions for the patient, for the
principal.
Yeah.
That's right. That financial power of attorney, the principal gives the agent, the person they are nominating, the authority to make financial decisions for them if they're not able to. At the bare minimum, those are the things we're talking about. Those are the things that we put in place, right? How many people have powers of attorney? You got to get everybody in here. I saw 2 hands. That is the bare minimum. We have to get every single person in here having a power of attorney for healthcare and financial. Tomorrow's not promised. We cannot take for granted what we have today, right? So, if something should happen to any one of us, and we're not able to communicate our health or medical decisions, or any decision, who's going to make those decisions for us? That's where we've got to get somebody that's trusted to make those decisions when we're not able to. All right? So that's where we start. We're going to get to the questions in a minute. Please remember that question. And from the powers of attorney, right, we also want to make sure that you have a living will. Different from a last will and testament. What's the difference? A living will is that document that spells out with specificity what kind of medical treatment or intervention you want if you have a terminal condition and you're unable to communicate your decisions. Right? So, if you're in the hospital and the doctor has said that you've got a terminal condition, terminal illness, right? Meaning a terminal illness is an illness that you are not able to recover from. There is no medical treatment, bless you.
Thank you.
There is no medical treatment that can reverse your condition, right? And if you are unconscious, I've got a client right now in Jefferson who is unconscious and unable to make medical decisions. I was appointed by the court to be her guardian because she didn't have powers of attorney, right? So, the living will, in that situation, will say, do you want to be resuscitated if you stop breathing? Do you want to be on a ventilator if you stop breathing? Right? It is those types of decisions that the living will expresses. And that's why you want to make sure you have your living will, financial power of attorney, healthcare power of attorney in place. Bare minimum. All right? So we start there. And then we're going to talk about what happens when you pass away. Because the powers of attorney and the living will all play a vital role while you're living. Right? But what happens when you pass away, when you pass on? What's going to happen to your property? So we need to look at wills, we need to look at trusts. But today we're talking about asset protection, right? The only way you're going to protect your assets today is through trust. Right? That's the discussion we're going to have today. Because if you set up a will, you identify who's going to receive your property, and we're all familiar with wills and what it is, right? You identify an executor, someone who's going to carry out your wishes. You identify your beneficiaries, the people who are going to receive your property. You identify your property that's going to be given away. And so you do all that, but if you should ever need long-term care, the will is not going to protect your assets or your property. Everybody heard that? Yeah. So if you need long-term care, the will is not going to protect your property. Now, social media, there's people giving advice and doing all this stuff. Don't listen to social media, right? The information that you have here today, you pass it on to people, your friends, your family, right? You got it from a trusted source. Mm-hmm. So, what do you do if you done your will and you want to protect your property to make sure that your property can go to your loved ones? Put it in a trust. Which type of trust, right?
Revocable?
What'd you say?
Revocable.
No.
Irrevocable.
Irrevocable, right? There are two types of trust. Irrevocable, IRREVOCABLE, and revocable, right? So let's talk about the two types of trust. The revocable trust is a trust, and the trust, think of it as a box where you put all of your property and all your prized possessions into. That's a trust. A trust, you put your property into that box and it goes to your beneficiaries. A revocable trust, as it sounds, you can change it at any point. You can change the trustees, you can change the beneficiaries, you can even change the property that you have in the trust at any point. Very flexible. But it does not protect your property from long-term care. It does not protect it from Medicaid. It does not protect it from the state coming in and saying, you need to use the money and the property in that revocable trust to pay for your long-term care costs. Okay? Revocable does not protect your property from the long-term care costs. The other type of trust is the irrevocable trust. Now, the irrevocable trust, under the Medicaid regulations, right? And we're basing all this on laws and regulations. This isn't hyperbole, this isn't supposition. This is grounded facts, grounded case law. So the information I'm sharing with you is what prior cases have already tested and the Medicaid regulations provide for. All right? So the irrevocable trust is that trust that protects your property. If the trust is prepared the right way, with the proper Medicaid regulation language, it protects your property from long-term care costs and for Medicaid. But you know, what you get comes with restrictions, right? So the irrevocable trust, if it's going to give you all of this protection, there's got to be more to this, right? And the more is this. You don't have the ability to move your property in and out of the trust the way that you do on the revocable trust. So if you put $100 into your irrevocable trust, that is the principal that has to stay in the trust in order for you to get the protection. Now you can earn interest on that $100. That interest is considered income. That income can be distributed to you at any point. I'm going to say it one more time. The $100 is the principal, has to stay in the irrevocable trust, cannot come out. The interest, if you have that $100 invested in a CD or some other, high yield savings account that earns interest, that interest is income that you can pull out of the trust. All right? And you also have to keep your property in the irrevocable trust for 5 years in order for it to be protected. 5 years. Right? So it involves a commitment. Right? So the other thing with the irrevocable trust is that you want to make sure the beneficiaries that you identify are the beneficiaries that you want to receive your property. Because remember, changing beneficiaries, you can't do it. Well, I shouldn't say you can't. It's very difficult to do it. Right? If you want to change beneficiaries, if you want to change the trust, what do you have to do? All of the beneficiaries either have to agree to that change. That's called a non-judicial settlement agreement. Or you have to go to court. Yeah. No, seriously. And so that's why it's important that you sit down with an attorney that understands all the dynamics of an irrevocable trust, right? So that's the irrevocable trust, and that's one way that you plan, right? That's the planning ahead. Now, what happens if you have the crisis planning, right? You haven't sat down, you haven't set up that irrevocable trust, you didn't do all the prior planning, and your loved one has to go into the nursing home tomorrow. How do you deal with that? That's where you have to do something like a spend down, right? And so the Medicaid regulations permit certain non-exempt, right? Or rather, it exempts certain expenditures, right? So some of the expenditures that the Medicaid regulations permit is, for instance, if you have a home and you need to do repairs to the home, the person that's going into the nursing home, right? You can do repairs on that home. And Medicaid will allow the expenditure of that person's money, right? If you have a car, you're married, right? Or the person that's going into the nursing home has a caretaker, and that caretaker's car just is on its last leg, right? The Medicaid regulations will allow you to purchase a new car. Sometimes, if you go to some of these nursing homes, you might see BMWs, Mercedes, you see some of these vehicles in there, right? That's what these people don't. Right? Medicaid regulations also, if you are married, right? It doesn't really matter whether you're married or you're single. You can elect to protect your house, your primary residence, by indicating that you have an intent to return home on the application that is filed for you for Medicaid. People don't know that. But if you do not elect, I intend to return home, the house will not be protected.
Are you still talking about the trust?
No, this is crisis planning.
Okay.
Yeah. This is crisis planning. This is where a loved one or someone has to go into the nursing home tomorrow, and there wasn't prior planning like with a trust. Okay? This is where you have to spend down money of that individual, right? So why do we need to spend down money, right? I know you're probably asking that question. Well, the Medicaid regulations say that for an individual who earns more than $2,829 a month, if you earn more than $2,829 a month, you are permitted to only keep $2,400 if you are single in assets. If you earn more than $2,829 a month, Medicaid regulations say that you can only keep, if you are single, $2,400 in assets. They want you to be destitute. That's why we want to plan ahead, right? So that's why if we are in a crisis planning and you have not planned ahead, you've got to spend down your money to meet those thresholds. All right? Now, if you're married, they'll allow you jointly, right? They'll allow you jointly to keep $154,000 and $140 joint assets, meaning the assets that you and your spouse own together. Not income, assets. Property. That means savings, retirement money. It's not a lot. Right?
Better than me.
So, if you are an individual, right? Let's look at the individual person. If you are an individual and you earn more than $2,829, remember that number. This is for 2024. Number changes every year. All right? If you earn more than your income, Social Security, pension, wherever that income is coming from, if it's more than $2,829, you get to keep how much as an individual? $2,400 in assets, property, right? So if you have retirement income or retirement savings or 401k that has $100,000 in there, guess what? You got to spend that down. That's crisis planning.
Wow.
So how many people like the planning ahead versus the crisis planning? Right? Right? So, now it doesn't get much better if you're single and you earn less than $2,829. They'll allow you to keep $8,000. Right? So, that's why we want to plan ahead. All right?
And
I saw we had some questions, please, go ahead.
So what if you had like, a business, what if you had like a business or an LLC and you banked under your business, would that protect you from?
That's a great question. That's a really great question. So the question is, if you have a business versus an LLC, will that protect you in some way? So the answer is, it depends. There are some situations where the business assets can be protected, meaning they would be meaning they would be exempt from Medicaid. All right? Those are situations where we have to look at it on a case-by-case basis, look at what those assets are, and that they are not tied to you personally. That's why if you have a business or an LLC, you have to create that clear separation. Separate bank account, no personal guarantees, right? Because if you've got a personal guarantee to a loan or some asset, then that isn't going to protect that asset, right? So we've got to look at what the assets are in the business.
Okay, also, so when you say that, does that mean using your personal social security number versus, or being a sole proprietor versus like a DUNS number?
So the question was, is there a difference using your own social security numbers versus a DUNS number, right? So for a business, right, you can either use your social security number, which ties into you personally as a sole proprietor, but if you become an LLC, I know we're kind of going off a little bit, but it connects in what we're talking about. You want to set up a separate tax ID, separate employer identification number. The DUNS number is a number similar to your credit reporting. It's the credit reporting for businesses, right? That's how they assess your credit worthiness as a business, your DUNS number. That's like the equivalent of your FICO score for you personally. All right?
Attorney, are you saying it's DUNS?
DUNNS.
DUNS.
DUNS, DUNNS. That's for business owners. Did I answer your question?
Right, so just so I'm clear, so in the situation we was talking about, if I have a business account, but I used a DUNS number versus me, will I be protected when it comes to loans?
Not with the DUNS number,
Not
no.
with the DUNS.
No, you have to get a tax ID, a separate EIN. So you'd have to get that from the IRS. Okay. Another question?
When you mentioned about the amount of money you have to have left, I'm sorry. When you mentioned the amount of money that you have to have left, what then do you do with your retirement, pension, 401, 403? What do you do with that money? Where do you put that money in so that it can be secured, and how do you move it so that you best protect yourself?
That's a great question. So the question is, if you've got retirement money and you want to protect it ahead of time, where do you put that money, right? So it depends on your age, right? That's an important criteria. Because if you are...
I'm sorry, so if you've been working like 24, 25 plus years in your early 50s, and so projecting maybe, you don't know what life is going to do, but you're projecting, and so, and then you worked for a corporation where they match dollar for dollar.
Yep.
And so,
How do you protect
there are
that?
tons of money in there, right?
Yeah.
How do you protect that?
Yeah, and so this is the thing. Retirement money cannot go into your trust because the retirement money is attached to you personally, your social security number, you as a person. So a person in their 50s, what we have to do is we have to have a serious conversation, right? And that's where we look at the health history of your family, look at your health history as well. Because if you can wait, let's say maybe till you're 65, where if you liquidate those retirement money, you're not going to get a penalty, right? And then you put that into your trust. That's a possibility, right? But we have to think about your health, your current health, your family's health. because if you're in your 50s and you liquidate that, you're gonna get a serious penalty, significant penalty. So, you know, that's part of the planning discussion, the strategy discussion that we would have in looking at a scenario like that. There isn't a one size fits all in that scenario. All right, yes.
Could you have more than one trust?
Yes, you can have more than one trust.
And my second question, what was the number for the couples?
Oh, the combined assets?
Yeah.
That's $154,140. 154,140 in combined assets, right? So let's talk a little bit about that, right? So a spouse, let's say your spouse has to go into a nursing home, and the $154,140, that's excluding your house. That's not including the house, right? So let's say you've got, you've saved money in a joint account. Let's say you saved $200,000, right? And your spouse has to go into a nursing home. What the Medicaid regulations is saying is that out of that $200,000 combined, right? Not yours separately, because you're going to have your separate 401k, your separate savings you might have. But the joint assets that you have together can be no more than $154,140 for 2024, right? So if you've got $200,000 in joint assets, you've got to spend roughly about $46,000 down. All right. Was that helpful? Okay. Yes.
Okay, when you talk about the clear separation, does that mean that you cannot use or switch money between your business account and your personal account?
Correct. If you want to do that, what I suggest is that you either pay yourself an income. So the question is, if you have a business, moving money between the business and the personal, your personal accounts. What I suggest that you do is you either pay yourself an income, or if you personally are putting money into the business, do it as a loan and have a loan agreement with the business.
Or write yourself a check from the business to your personal name, right? From your business.
But on the note section, if you're gonna write a check from the business to you personally, write it as kind of a draw for the owner, or some type of income. But I would just write it as a draw, owner's draw. Okay. Yes.
Okay, so I have two questions. The first question with the irrevocable trust.
Yeah.
And the beneficiaries, because you're saying if it's unchangeable. So my question is, what happens if the beneficiary is no longer able or around, and you have an irrevocable trust? Oh, I thought my voice carried.
All right. So the question is, in the irrevocable trust, if you have a beneficiary named, and that beneficiary passes away before you do,
All right.
and you can't change that irrevocable trust, what do you do?
Probably a clause.
So it would go to the second.
Hold on.
You should have a second person, so you have a list of beneficiaries. So if something happens to the first one, then it goes to the second one, and so on and so on.
Amen. That's it, right? That's it. You have multiple beneficiaries, right? So if one beneficiary passes away before you do, it goes to the next set of beneficiaries, right? But you should always, and this is why it's important that you talk with an attorney, because in my office, that money goes somewhere. It doesn't just sit there, right? There's always some contingent beneficiary, right? All right. So it could be individuals, it could be the church, it could be a nonprofit, It will go somewhere.
Okay.
Alright, so I know we got some questions, but look, I wanna do this, right? One thing, that I wanna mention, right, with Medicaid, there's a look back period, right? So when we are applying for Medicaid, right? Doing a Medicaid application, there is a 5-year look back period, right? Where the state or the county you're applying for the Medicaid is gonna look back through your financial history 5 years to see how you have, what's happened with your finances? Have you given money away, right? That's what they're looking for. Because I know some people will tell you, well, hey man, look, just give your money away. But if it's within 5 years, guess what? They're gonna see it because you have to turn in your bank records, your financial records, they're gonna see it. And they're gonna ask for that money back. They're gonna ask you to put that money back. If you can't put it back, then they're going to have a period where you are disqualified for Medicaid. All right? So, that 5-year period, that's why we want to set up this trust, right? Put your assets into that trust. We're not going to give any money away or anything during those 5 years that prior to when you need that Medicaid application file. All right? You had a question?
Quick question. Does the Medicaid regulations change state to state, like we move from PA to Delaware?
There are some nuances. And so the question is, does the Medicaid regulations change from state to state? Medicaid regulations, it's a federal rule, federal regulations, right? But there are state-specific nuances. And that comes into, like we were talking about, right? If you earn more than $2,829, you can keep $2,400. Those are state-specific nuances. So if you move to Delaware, Delaware may have a different income guideline. But as a whole, Medicaid is a federal regulated law and regulation. So the things that will stay the same are the limits, that we talked about, the income, the $2,829, and also the amount that couples are able to keep, right? The joint assets. Those things will stay the same, but how much, based on those numbers an individual can keep will change from state to state. All right? So everyone that came in has received a flyer. If you turn to the back of your flyer, you'll see a questionnaire, right? If you have not filled in that questionnaire, please do so now. I'll give everybody a few minutes to do that, and I'll take some questions as people are filling that out. All right?
Can I ask a question? Can I ask a question?
Yes.
So outside of the Medicare plan, what would be the benefit of using a irrevocable trust versus a revocable outside of that?
Great question. Great question. So the question is outside of Medicaid planning. But what we want to say, this is important. I know I've been using the term Medicaid planning, right? But the true terminology is asset protection planning. And I'm going to tell you why. Because the government frowns on Medicaid planning to protect your money for Medicaid. Right? So there are attorneys with the County Assistance Office. The County Assistance Office is the entity that accepts applications for Medicaid. And the Office of General Counsel is the attorneys that represent the County Assistance Office, right? And so there are a number of cases where they've prosecuted individuals for moving money, planning for Medicaid. So one thing we want to make sure that as we discuss this, we discussed this with the true way of protecting each and every one of you. Asset protection planning, ASSETS, assets protection planning. If you're planning to protect your assets, that's part of estate planning. They can't come after you for that. All right. I'm sorry. What was the question?
The question was, what's the benefit outside of the
Yeah.
Medicaid? And also, is it transferable? So if I did revocable today, because isn't it like, a risk thing? Like when you're younger, you're taking more risk. Because what happens if I put a property in a trust, but I sell it, or if I wanna refinance, or if irrevocable trust isn't gonna allow me to leverage my money that way?
That's right. That's right. And that's a good question. So, multiple parts to the question, right? First part is, what other advantages are there to the irrevocable trust other than asset protection planning? So, the irrevocable trust also protects your property from lawsuits. All right. So, if you have property assets in an irrevocable trust, all right? So let's say you own multiple investment properties, right? And you have them set up in LLCs, right? And you have your LLCs, you know, in your irrevocable trust. You've got 2 LLCs, you've got 2 properties, 2 LLCs set up in the irrevocable trust. If someone sues you because they tripped and fell on property 1, they can't go after your other assets in the irrevocable trust. Right? And the question is, other part of the question is, you know, if you're a younger person and you've got property, but you don't want to lock it down, right? You don't want to, you know, have it in this irrevocable trust and not be able to move freely, right? Then we're going to talk about having a hybrid, having a revocable and an irrevocable trust, right? And I've done that for some young investors, right? Gives them, the revocable trust gives them the flexibility to kind of move in and out, move their property in and out of that trust, while the irrevocable trust, they can put a property or certain properties in that trust that they don't need to move in and out, right? And so that's where we do the customizable planning based on unique situations. Did I answer your questions? Okay. Any other questions? Yes.
There was a question I had earlier, you told me to remember, I think it's about the beneficiaries or the power of attorney for healthcare and financial. Should those be the same individuals, or is it wise to make them 2 separate individuals? And based on age?
Yeah, great question. So can the agent in your healthcare power of attorney and your financial power of attorney be the same person? Yes, they can. But this is important to note, right? Some people don't have the stomach as your healthcare agent to do what you're asking them to do. They love you, and when you're at your worst, your internal condition, you're asking them to let you go. Will that person honor your wishes? That's the important thing, right? And so, while someone may be great for your financial agent, they may not be able to honor your wishes as your healthcare agent. And that's the question you really have to answer. And if the answer is yes, then they can be the same person. And you had a second part?
That was it.
That was it? Okay.
I think she answered one about the beneficiary.
Okay. Did everybody get a chance to fill out their questionnaire? Is anyone still going?
Attorney, I have one question.
Yes, sir.
So we're talking a lot about potentially having to spend down in situations in order to qualify for Medicare for long-term care. So my question is there a scenario where either it doesn't make sense to spend down because you as a family unit is well off enough, or have financial savings set aside some way to pay for it, so you don't have to spend down in order to qualify for something like long-term care?
Yeah, I love that question. So the question is, are there situations where it doesn't warrant spending down assets, right, to qualify for long-term care or to qualify for Medicaid, right? And so let me give you some numbers, right? Monthly long-term care costs in Pennsylvania averages anywhere from $13,000 a month to $20,000 a month, right? So multiply that by 12, right? We're talking about $150,000 to about $240,000 a year, and the average person, I believe the average woman stays on or needs nursing home care, I believe that's 8 years on average. The average man, I believe, is slightly lower, 5 or 6 years, right? So you multiply that by 5, right? Yeah, y'all have me doing math in here today. So you know, we're slightly.
It's a lot.
It's a lot, right? It's a little bit less than $1 million, right? Right. So what's 150,000 times 5? That's about 750,000, I believe. Is my math right? Right. So it's about 750, 800,000 for 5 years. And if they both need it at the same time, right? So that's the calculation you have to kind of do, right? And if there are sufficient assets to pay for that, then in that situation you wouldn't have to worry about spending down or Medicaid. Does that make sense? Or if you have long-term care insurance.
Would is an IRA or self-directed IRA a form of protection?
No.
No.
So the question was, is a self-directed IRA, which is what business owners have, you know, they can put money into the IRA, but remember the IRA, the retirement account is tied to you personally, right? It's a type of retirement account. Yes.
I remember now, the living will, where, you said the individual, the living will, where you said the individual would have to make the decision on their end. So my question is, what if you don't really know what you want that to be, or if you make a decision, like pretty much when you're healthy, but then when you're ill, sick, it's like, I may not want that anymore.
Yeah.
How is that handled?
Yeah, and so the way you look at your planning, right, it's not set it and forget it.
Okay,
Review it every year.
okay.
Make changes, right? Because the friend that you have this year, next year you may not be as friendly with that person, right? And if you appointed them as your agent, as your executor, you may want to make a change. And same thing with your wishes. You may want to change that, right? You can amend all your documents except that irrevocable trust pretty easily. So once you create it, review it every year. My advice, you know, tie it to something that you do on an annual basis every year, whether that's spring cleaning or your birthday, taxes. Don't get me started with taxes.
That's good.
All right. Everybody filled out their questionnaire? All right, so now I know I know folks have notes on that questionnaire. How many people have notes on that questionnaire?
The question is.
You guess a maybe?
In between, you know, yes, no, I know.
All right. So, if you got a maybe, or you have a no, I encourage you, on the front of the flyer, there's a QR code, where you can get a free strategy session, right? So, that QR code right there, that'll allow you to get a free, strategy session. Normally I charge $200 for it, but for everyone here today, you're gonna get a free strategy session to talk about those notes, right, and those needs. Because, you know, we wanna make sure that you do proper prior planning to make sure that you're okay, right? Yes.
It's funny how they're like, okay, so my question was, does that have, oh Lord. The question is, does it, as a couple, if we're not able to come together, will I be able to come free and then he later come free?
Yes,
Awesome.
Amen.
yeah, absolutely,
Oh.
absolutely.
I have one last question.
All right, yeah.
You mentioned about a client in Jefferson. At what point does the state government appoint you versus like family members?
Great question. So, the question, concerned, the client that I have in Jefferson Hospital that I am the guardian for. And the question is, at what point do I, get involved, an attorney, as opposed to a family member? So, in Pennsylvania, the preference is to have a family member serve either as the healthcare representative or the guardian for that individual. But if there is a situation where there's conflict with the family, then, and decisions cannot be made, then the court will appoint someone like myself, an attorney or an independent guardian. So the healthcare representative statute in Pennsylvania allows a parent, sibling, child of an incapacitated individual to make healthcare decisions for that individual. So sometimes what will happen is if a guardianship action is filed in court, you may see that the court may say on the healthcare side, medical side, we're going to appoint a healthcare representative as opposed to a guardian. But on the financial side, if the person is incapacitated, the court will appoint a guardian to manage their finances. Any other questions? So, when do we start, right? That's the question. When do we start planning? When do we start doing this?
Yesterday.
That's right. We start right away, right? Because, I'm gonna tell you, I've had this situation happen once. Client came in, we prepared their documents, kept calling them to come in and execute it. Client kept pushing it off. So what we did was we mailed the documents to the client, gave the client the names, phone numbers, emails of traveling notaries that can come to their house, and so we packaged it for the client. Client still didn't execute. Client passed away. Client was separated from their spouse. They were still married. The spouse got it. All right. So, when do we start?
Now.
When do we start?
Right away.
Right away, right now. So, we start right now, and these are the things, right? So this checklist is kind of like, it gives you kind of a starting point, right? Things that you want to start doing, right? You kind of use this and you kind of say, okay, this is what I'm gonna start with, right? Let's take a look at the checklist. All right, we're gonna take a look at the checklist. Right, and so the first question was on the personal information. Have you compiled a list of important contacts such as family members, friends, doctors, legal advisors, right? So if you haven't done that, that's where you start. You start by doing that, and you just go down this list. And I want you all to make this commitment to yourselves, that you will go down this list so that every question is a yes. And I'm going to come back. When do you all want me to come back?
6 months from now.
September? All right, so I'll come back in September. And we're going to see, because I want to see everyone here back in September. I want to see that everyone has done this checklist. And I want to see all yeses. All right. September.
Oh, yes, no, like, oh, yes.
Yeah, it's May 25th.
I know, right?
All right. Well, we'll make it toward the end of September. Give people some time. All right.
So all these categories here,
Yes.
is it each type of service that you offer, or is this like a bundle?
Yes. We do it all together.
Okay.
Yeah. So the operative word is, do we bundle?
Yes,
Yes.
okay.
Yes, we bundle these. Yeah. All right.
It is.
But, so I heard the word overwhelming, right? So you all heard this phrase before, right? You got an elephant. How do you eat the elephant?
Little by little.
Piece by piece. One bite at a time. One question at a time. Don't look at the full list. One question at a time. If you do one question a day, by the time September rolls around, you will have finished this list. All right. We got a commitment. What's your name?
But she's like that, she's a planner.
Rena says she will be done tomorrow. All right. So we're all gonna hold Rena accountable.
Yes.
You know, she's a planner.
She's like, that's what she said.
Not a month from now, not 6 weeks.
All right. All right. Yeah.
I have a question about, life insurance, like for your adult children, term.
I'm sorry. I have a question about life insurance, for your adult children, like term life versus whole life, which is better and more beneficial and?
Yeah. So term life versus whole life. Now the children are the individuals that are getting the insurance, or they're going to be the beneficiaries? Both?
Both, yes.
Okay. So, I love the question. I'm a big proponent of getting life insurance for your children, meaning having them own life insurance, because it's cheaper when they're younger. Now, I am not a life insurance broker or a specialist on life insurance, but I know individuals who do this day in, day out. But one thing I'll share with you is this, and I've done this for my own children. When they are young and you purchase whole life for them, with a policy that has cash value that can grow with them, And it also has to have a feature where as you build the cash value, there's enough equity built in that at some point you stop paying the premium and the insurance pays for itself, the cash value. So if you have an insurance person that you speak with them about it. If you need someone, I can refer a couple people to you that you can talk to. But life insurance is an important component. It's something that I discuss with my clients about generational wealth planning, because if you set up a trust, you can make the trust the beneficiary of that life insurance. And that life insurance can continue, right, for years to come. The life insurance proceeds will fund that trust. And the beneficiaries of that trust would be your children, your children's children. You all heard of the Rockefeller, Rockefeller Fund, a lot of these funds. How do you think they set up these funds? These trusts with life insurance, right? So all of this is proper prior planning. To what? To make sure that we're okay. Right? Yeah, that's right. Did I answer your question?
Thank you, yeah.
Yeah. So what I wanted, yes, you have a question in the back.
Does it make sense to have a life insurance separate from your job insurance? Do you need to have both?
Yes, yes. The question is, does it make sense to have life insurance separate from your job? And the answer is yes. You can move on from that job, but you want to make sure that, you have life insurance outside of that job, should you move on from that current employment. All right. So let's recap. We talked about proper prior planning, right? Making sure that at minimum we have what? We have powers of attorney and a living will, right? That's what everyone's going to commit to. So when I come back in September, I'm looking forward to seeing every single hand raised that you have the powers of attorney in place, you've got your living will in place. Can everyone say they're going to make that commitment? They're going to make that commitment. I'm going to make that commitment to myself. Can we hear everyone say that?
Yeah.
All right? Because that's what you owe yourself. Right? And then from there, we're going to have discussions with me, or whether you go with another attorney, right? But it has to be an elder law attorney. Elder law attorney. About protecting, asset protection, right? Should you ever need long-term care in the future. Right? So we've got to have that discussion and strategize on how that is going to look for each and every one of us. All right? And then the final commitment is that folks are going to use this checklist, and when I come back in September, it's all going to be yeses.
Yes.
Once again, I am going to commit to answering every question on this questionnaire with a yes. Let me hear you say it to yourself. I am going to commit to answering every question on this questionnaire
Are you going to commit to work on the church?
All right. So, if you need to connect with us, there's a QR code here. We'll hang out, Zainab and myself will hang out for a little while. We'll be at this table. If you wanna give us your name, we can take your name and then schedule a consultation. All right,
After church.
after church?
She'll be here tomorrow.
I love it. All right, any final questions before, we wrap up? Yes.
What if you don't feel like you have someone set up to put in place?
If you don't have someone,
Yeah, that you can name or set up and put them in place. I don't think I have anybody reliable out there
yeah,
that could handle any of this.
yeah,
Because I'm the one who does it all.
yeah,
And based on what I've seen from them in the past, health-wise, they're not reliable, money-wise, they're not reliable. I don't feel like I can use any of them. So what am I supposed to do?
that's a great question. I get that from time to time, and, so, our firm, we serve as powers of attorney, we serve as executors, we serve as trustees. What I tell folks is I say, you know, think deeply, extend your reach, you know, to your circle. If there are other individuals that you think may be able to do it, think of them. If there is no one, we can have a discussion about whether it makes sense for our firm to be in that position. There are other law firms that do that as well, so, you know, if you do have an attorney that you work with, ask your attorney, you know, the same question. Yes, ma'am.
I have 2 children, and I really don't want to leave things where one have more say than the other. So how do you address that? I don't want them fighting when I'm gone. I want things to be.
Now, this is the thing. If you're concerned about them fighting, there's not a whole lot that you can do, right?
True.
But the thing that I want you to keep in mind, this is planning for you. You're not planning for them, right? So you put the person in charge that's gonna make the best decision for you. Even if it means that the other child is not gonna like it. All right? All right. All right.
Thank you.
All right, my pleasure. Thank you, everyone.